Yes.
Judge, just before we bring in the jury to call the next witness, I did just want to bring a legal issue to the court's attention. Attorney Schoenhorn indicated to me yesterday that he would be objecting to the AT&T records coming in without an authenticating witness. I don't know if that's still his position, but it was my intention to use those records at this time.
I will just note, Your Honor, that the state provided me with an affidavit which I believe does not comport with new Code of Evidence 9-3A, although there are two affidavits. One is dated yesterday, or maybe, what's the date? Not yesterday, a couple of days ago. The other is dated a couple of months ago. In any event, I submit that, well, there are two issues. One is it states that the specific records and the certification have to be provided in sufficiently in advance of the offer to provide an adverse party with a fair opportunity to challenge them. So this was provided within the last couple of days, this affidavit. But in any event, I don't believe the affidavit complies with subsection A3 of new 9-3A. It appears to, on its face, the business record affidavit comply with a federal rule. It specifically recites the federal rule, but Connecticut's Code of Evidence is different in that respect. And specifically, it requires that the affidavit state either that it is based on the entrant's own observations or on information of others whose business duty it was to transmit it to the entrant. And I submit that neither of those are in the affidavit. Therefore, I've indicated to Mr. McGinnis, actually at least 2 weeks ago, that I was going to request that an AT&T representative appear. And I had indicated even to Your Honor that part of the issue was to explore whether or not these records were obtained or were subject to erasure that were therefore obtained in violation of the Fourth Amendment. But I'm just sticking right now, we're not making a constitutional argument to my claim that under new Rule of Evidence 9-3A, which was approved in 2022, that the affidavits do not comport with the requirements of that section under the business record authentication requirement, and therefore a business custodian of records would be required to testify.
Judge, obviously I disagree. I think that the affidavit itself fully complies with 9-3A. Just with respect to notice the opposing party, my recollection is we've been going back and forth as to whether or not someone was going to be required. And it wasn't really until last week that Mr. Schoenhorn indicated yes, for sure, that he was going to demand that someone from AT&T be present. But I'll just note the following for the record. With respect to Mr. Dulos' records, I would imagine he's had those for several years, although I guess he could represent the specific date. I wasn't involved with the case at that point. And with respect to Mr. Troconis' records, he's had those since at least November 16th, and that affidavit is, that was a more recent search warrant, as the court will recall. And I could pass forward a copy of one of the affidavits. They look the same if the court wants to, check it against the subsection. But I can tell you, Judge, that this affidavit fully complies with 9-3A. It indicates that the person making the affidavit is qualified to authenticate the records because they're familiar with how the records were created, managed, stored, and retrieved, that they are true duplicates of the original records. They were made at or near the time of the occurrence of the matter set forth by or from information transmitted by a person with knowledge of those matters. They were kept in the ordinary course of the regularly conducted business activity of AT&T, and they were made at AT&T as a regular practice.
I would ask the court just to look at the affidavit. And like I said, I think that the business record rule may be an exception to the confrontation clause, but I would argue that it would have to be strictly construed in order for that to be admissible. I have no objection to the court looking at it. I believe it doesn't comply, and it would be a simple matter to look at.
Well, if it's a confrontation argument that they're making, Judge, then you can dispense with this pretty easily. These are business records that are not kept for the specific purpose of criminal litigation. And so obviously if they're kept in the ordinary course of business, as this affidavit attests to, then there is no testimonial piece of this because they weren't generated for the purpose of criminal litigation. So I think if that's the argument, then I think the court can quickly dispense with it. But I'm happy to pass forward a copy of the affidavit.
Thank you. Well, the court hears two arguments. The court hears one argument concerning authentication